So, good day ma'am, my name is Raja Esanki. Number 6, PV versus Holgado 2014. So, People versus Holgado, one case is People of the Philippines versus Roberto Holgado Y. de la Cruz. GR number 207992, decided on August 11, 2014 in the Philippines. So this case is involved charges against Roberto Holgado and Antonio Misaris for violating section of Republic Act number 9165. So that the Comprehensive Dangerous Drug Act of 2002. Holgado was accused of selling drugs to an undercover police officer in a bypass operations. The main issue in the appeal was whether Holgado's guilt was proven beyond a reasonable doubt, particularly regarding compliance with the chain of custody requirement for seized drugs. So here are the rule of court. Strict adherence to Section 21. The court emphasized that the law enforcement agents must strictly follow the procedure for inventory and photographing of seized drugs immediately after the seizure in the presence of required witness or accused representative, a media representative, a Department of Justice representative, and an elected public official. Number 2, integrated of the corpus delict, rather. Failure to establish a broken chain of custody creates doubt about the integrity and identity of the seized drug or the corpus delicti or body of the crime. So the court stated that this doubt must be resolved in favor of the accused. Number 3, presumption of innocence over presumption of regularity. So, the court clarified that the presumption of regularity in the performance of official duties cannot prevail over the constitutional presumption of innocence, especially when there are significant unexplained lapses in the chain of custody. So last but not least, minimal amount of drug. The decision highlighted that non-compliance with legal requirements should not be taken lightly by law enforcement, especially true when only a minuscule amount of dangerous drugs is alleged to have been taken from the accused. So number 7, Vivi versus Floor, GR number 262680. On January 9, 1993, at a dance party in Laguna, Hermogenes Flora, upon a signal from Edwin Flora, shot Emerita Roma and Ireneo Galarte, who both died, and also shot Flor Españas, who survived. Edwin Flora threatened Rosalie Roma, a witness, before he and Hermogenes fled. Edwin was arrested that morning, while Hermogenes fled to his hometown. So both Hermogenes and Edwin Flora were charged with murder for the deaths of Emerita Roma and Ireneo Galarte, and attempted murder of Flor Españas. So the main issue was whether the trial court erred in convicting the two accused appellants despite the prosecution's failure to morally and guilt for the crimes charged. So the Supreme Court held Hermogenes Flora guilt beyond reasonable doubt of double murder for the deaths of Emerita Roma and Ireneo Galarte, and guilty of attempted murder of Flor Españas. Edwin Flora was also found equally guilty in conspiracy for the murder of Ireneo Galarte. So, however, Edwin Flora was not found responsible for the death of Emerita Roma and the injury of Flor Españas, as the conspiracy only extended to the killing of Ireneo Galarte. So, examining Section 4 of this court's rule of on violence against women and their children, which states that family members includes among others husband and wife, parents and children, we ascendants or descendants. The Court of Appeals ruled that the province does not limit what children means and thus may include the spouse, adult children. It cited Section of 4 of Republic Act number 9262, which calls for the law's liberal constructions to attain in objective of protecting abuse victims. So, number 8, Estacio versus Estacio. So, Estacio versus Estacio or GR number 211851, September 16, 2020. Roberto Estacio Y. Salvosa, petitioner, versus Maria Victoria Estacio Y. Santos, respondent. So, a stay-away directive in a protection order may cover members of the household including a couple's common children if it is shown that the offender commits violence against the victim through the household members. So, this court results of petitioner for review on a certiorari, assailing the decision of the Court of Appeals. So, which means for affirm that the regional trial court decision making permanent and issue temporary protection order. So, in Roberto Estacio and Ma Victoria Estacio have been married since January 2, 1973. They have 3 children, namely Manuel Roberto Maria, Katrina Ann, and Charlene May, who were all adults at the time of the controversy. On December 7, 2011, Victoria filed before the Regional Trial Court of Parañaque City a petition seeking a permanent protection order under Republic Act 99262 or the Anti-Violence Against Women and Their Children Act of 2004. This came with an urgent prayer for a temporary protection order. After finding the application sufficient in form and substance, that Regional Trial Court issued an ex parte temporary protection order which contained the following terms. Number 1, prohibiting respondent from treating or committing any acts that constitute acts of violence, from directly or indirectly harassing, annoying, contracting, or otherwise communicating with petitioner, including the sending of harassing, degrading, demeaning, and or threatening text, messaging, or any others. Number 2, to immediately remove his own persons from 77828 Beechwood, Gem Block, Phase 2, Marcelo Green Village, Barangay Marcelo Green, Parañaque City, where petitioner resides for the latter's own protections. Number 3, stay away from petitioner and her children, as well as other household members, including household help, a reasonable distance and may be specified by the Honorable Court. Number 4, to cease and desist from using or going near any firearm or other deadly weapon, and to immediately turn over any firearms that he may have to the court for appropriate disposition, including revocation of license and disqualifications of any license or CIC to use or to possess any firearm. So GR number 270257. So, in August 12, 2014, the petitioner versus People of the Philippines and respondents. So, before the court is a petition for review on certiorari filed by petitioner, assailing the decision on February 8, 2023, at the resolution on September 6, 2023 of the Court of Appeals, CA. So in CA GR number 45361, the CA affirmed that the judgment on July 3, 2020 of Regional Trial Court or RTC. So in Benguet criminal case number 18 CR 12464 that found guilty beyond reasonable doubt of psychological violence defined and finalized under Section 5 under the section 5 of Republic Act number 9262. So otherwise known as the Anti-Violence Against Women and Their Children Act. At the antecedents, the instant case stemmed from an information for violation of Section 5 of Republic Act number 9262 filed against the accusatory portion of the information reads that on the first day of January 2017 and the days prior and subsequent at Municipality of Province of Benguet, Philippines, within the jurisdiction of Honorable Court, the above name accused without any justifiable or justify cause or reason whatsoever did then and there willfully, unlawfully, and knowing subject his wife. So, and their children po to mental and emotional anguish, public ridicule or humiliation by abandoning them and living with other women, readily denying them the marital love, affection, and financial support to their children despite being financially capable to the damage and prejudice of said and their children. So number 10, Fifi versus Genosa 2014. So the case of People of the Philippines versus Marivic Genosa or GR number 135981 is a landmark 2004 Philippine Supreme Court decision that addressed the novel defense of battered woman syndrome or BWS. There was no specific 2014 ruling. The Fremari decision was issued on January 15, 2004. So here's the case summary. Marivic Genosa was convinced of parricide for the killing of her husband, Ben Genosa. In November 1995, she admitted to the killing but claimed self-defense, arguing that she had suffered years of severe physical and psychological abuse from her husband and was acting to protect herself and her unborn children after an acute battering incident. So the trial court found her guilty and sentenced her to death, finding treachery as an aggravating circumstance because her husband was killed in his sleep. So additional Supreme Court ruling or 2004 on appeal, the Supreme Court made the following key rules. Recognition of BWS or the court formally acknowledged battered woman syndrome as a scientifically defined pattern of psychological and behavioral symptoms resulting from cumulative abuse. So self-defense claim denied. So that the court found that Genosa did not meet the traditional legal requirements for complete self-defense at the exact moment of the killing. So in other words po, primarily because there was no imminent or unlawful aggression from her sleeping husband or BWS as a mitigating. So ang circumstance niya po, while BWS did not justify the act as complete self-defense, so that the court determined that the psychological paralyzed and diminished willpower caused by the years of abuse we equivalent to mitigating circumstance. So the penalty reduced or the court reduced her conviction penalty from death to reclusion temporal, a lesser prison sentence due to these mitigating factors and the absence of treachery. The prior argument meant the victim was forewarned of potential aggression, so release aggression. So release. So the court release ordered her immediate release as she had already served more than the minimum reduced penalty while waiting trial and appeal. So that's it po, and have a nice day.